Well set? Good. Good afternoon. My name is John Maley. I'm a Richmond native. I'm an attorney that practices out of Indianapolis, but do a lot here in Richmond through the Whitewater Valley Pro Bono group that I'm part of. Felicia here and Aubrey are part of staff. Thank you for being here. I'm going to talk about special education, and this is something that is near and dear to my heart. Growing up in Richmond, my sister used to volunteer at Green Acres. I don't know if that still exists, but it was a camp area for children with special needs. And then she went on to become a lifelong special education teacher, dealing in particularly with severe autism, children with severe autism. She just recently retired. And so I was familiar a bit because of her. And then I was involved in college, in Special Olympics, coaching. And then as my wife and I started our family, our first child, we had 5 boys, our first child, Joseph, was born with a myriad of disabilities and ultimately diagnosed with cerebral palsy. And so we went through special education with him. Me as an attorney, my wife as a passionate Italian advocating for her son. And as we did that, we started to have other families ask us lots of questions. And of course, we were interfacing with teachers, administrators, and sort of got to know the special education community very well. And so this is something that I spent a lot of time on myself, doing a lot of pro bono work with families, parents, guardians, helping children and families, and then speak on this topic a lot. So what I want to do today is just give you a primer. How many of you are any educators in the room? Okay. The rest of you parents, guardians, or just interested? All right. And everyone, just about everyone, knows someone who, or a family that has a child that either is receiving some sort of special education services, even if that's short term. Maybe you take a high school soccer player that ends up with 2 concussions. They may well need some special education services, some adaptive components to their education because of the recovery they're going through. Or it may be physical or behavioral. So most families, most people know a family that has a child that's getting some services, and some might know a child who isn't getting services but maybe should. And so what I want to cover is those basic rights and the primer. And happy to answer any questions. Don't hesitate to jump in as we're going along. This will probably take about 30, 35 minutes, and I'll take some questions after as well. We're recording this so that we can have this on our website at Whitewater Valley Pro Bono for people to watch on demand. So if you do ask any questions, I'll repeat them so that they're getting picked up. So first, in terms of the need for special education knowledge, there are actually hundreds of thousands of students in Indiana who need special education. Not all are getting that, perhaps because they haven't been evaluated and determined that they need those. And this is actually a very complicated area with legal rights and procedures. It's good. When I was young, I went to St. Mary's just down the road, then Test Junior High, and then Richmond High. And so I'm a 1981 Richmond graduate, so I was in Test, would be 75 to 78. The fellow students who were receiving special education, we never saw them. They were down at the very north end of the building, all by themselves, isolated, and so it wasn't good for us because we didn't interface with them. It wasn't good for them because they didn't interface with us. And that was a pretty common setup. And there were no doubt probably dozens and dozens of my colleagues who weren't getting special education services who today would probably be diagnosed on the spectrum or some other behavioral issue or perhaps dyslexic or whatever it might be. So we've come a long way and now have these rights and procedures that didn't exist 40 years ago. There's only a small number of attorneys that practice in this area, both nationally, in Indiana, and then take, say, in Wayne County, there's no one attorney that this is what they do day in, day out. In Indianapolis, there's a handful of attorneys that do this day in, day out. Most of those that do it actually represent and advise the schools, because there's a lot of complicated procedure for the schools to work through. So it's not an area, unlike others, family law, landlord-tenant, a lot of things that we help families with here at Whitewater Valley, that is very well known by lots of members of the bar. So what I want to do today is give you an overview of the framework, talk about some of the core principles of the federal law, the Indiana law, talk about the basics of what is often referred to as the IEP, the Individualized Education Program. I try to avoid acronyms, but this is one that gets thrown around very commonly within schools. But it's important for all of us to know what's that actually mean. So individualized, that's good. Joe or Jane are going to have a different program because they're different children, right? Different needs. And it's an education program. It's essentially, as we'll talk about, a contract with the school. Give you enough information that you could, whether for your child, whether for your niece or nephew or a neighbor, that you can be potentially supportive at a case conference and help in the development of the individualized education program. And then also introduce some core terms just for your knowledge so that you're able to discuss knowledgeably with schools or if you're supporting a family member. Generally, the more, like so many things in the law, the more people that have at least some awareness and knowledge of this topic, the better. And then sort of know where to go to find answers and resources. So the legal framework, first of all, gosh, we're now 34 years since we've had the Individuals with Disabilities Education Act, IDEA. So federal law passed back in 1990, reauthorized 2 different times, and like so many federal laws that then provide funding to the states then, if they accept the federal funding, like Indiana does and like all other states do, they've got to comply with the federal minimums. They can do more. They can spend more money. If the law says you got to have at least 10 days notice, the state might decide, let's make it 14, but you at least have these bare minimums that have to apply. And so one analogy that you think about federally, there's the EEOC, Equal Employment Opportunity Commission. Indiana has also an Indiana Civil Rights Commission, kind of a similar body, and Indiana could go further, but hasn't than the EEOC. So what's covered? So early intervention, so birth through age 2, then ages 3 through 21. And what Indiana does, the legislature said, yes, we're going to be part of this program. So they passed in the Indiana statute, Indiana code, the legislature said, we're going to do this, and we're going to authorize our Indiana Department of Education to promulgate rules and regulations to comply with federal law. So within special education, you'll hear teachers, administrators talk about Article 7, Article 7, Article 7. What's that? Sounds like something out of the Uniform Military Justice Act, right? Where do I find Article 7? Someone please give me Article 7. Well, it's actually in the regulations that the agency promulgates. So it's, the way lawyers find it, well, it's in Title 511, Article 7 of the Indiana Administrative Code. So you kind of think of law, there's the Constitution in Indiana, Indiana Constitution. Then there's the Indiana Code, statutes that the legislature passes. Then below that, various agencies like Department of Education, like the Civil Rights Commission, like Department of Transportation, pass what are called regulations that are been authorized by the legislature to say, you go manage that area. You have the expertise. And so this happens to be the website for that. Why don't we, Felicia, go ahead and close that. It sounds like we're in a car wash. And so this, does everybody have the handout, by the way? Okay. Give this to you so that, and those watching remotely as well, we can, you can email and we can provide it to you in PDF. This helps you find, here's where that actual law is if you want to go see it. There's also a very, very good document, 72-page guide that the Department of Education has promulgated, the Indiana Department, called Navigating the Course, Finding Your Way Through Indiana Special Education Rules. It's last updated in 2017. By the way, this is an area of the law that doesn't change very often. It's been fairly stagnant for 20 years, and that's generally pretty good. It's predictable, and it's a pretty decent basic foundation. This is a great guide. You can find it online. It's free there at the Department of Education's website, that frankly answers most questions that people have. And as an attorney, when someone is asking me what lawyers do, we can find the law. Some things we just know because we've practiced it over and over. But if somebody asks me, how many days do I have to do something as a parent? I don't have that memorized. I'm going to go look at it. And the place I'm going to first start is going to be this guide, and then it'll reference the law, and I'll go double check the law. All right, so core principles under the federal law in Indiana's Article 7. So let's list these, and then we'll talk about them. So the concept of the free and appropriate education, some people refer to it as FAPE. Again, I hate acronyms, but you might see that. It's like, what the heck is that? Are we at the vape shop or something? No, it's education. Then the appropriate educational evaluation. Does Joe or Jane, are they entitled to services? How does that come about? Then the individualized education program, the concept of least restrictive environment, which didn't exist back at Test Junior High when I was a kid, is they were in a restrictive environment. We didn't see them. They weren't intermixed at all. Mainstreamed, if you will, is a common term. Then procedural safeguards. Not going to drill deep into that, just going to comment on what types of procedural safeguards. And by the way, most of this law makes sense. If I were to charge you here in the group with, okay, what should parents and guardians be entitled to? What rights should they have? And should they get notice and have some time to respond? You'd come up with most of these. You might not have the exact same ones or the same deadlines, but it's a lot of common sense that's gone into this. Parent and guardian participation in decisions. That's a key element, key principle of this. All right, so let's break down these. Talk first about the free, appropriate public education. So every child that's in a covered state, so Indiana, is entitled by law to a free and appropriate public education. The key words, free. I went to test in Richmond High for free. Did I have some fees I had to pay to be on the cross-country and track team or whatever? But the basic concept of a free education. And then it's appropriate. That's the statutory and the regulatory term. Appropriate is individualized. If someone like our son Joseph, who was nonverbal, he had orthopedic issues, so he didn't walk particularly well. He was in a wheelchair a fair amount of the time. He had seizures from point in time. He had various different things in his life. So for him, what was appropriate? That's different than his classmate who maybe has a hearing impairment, but has top-of-the-chart cognitive abilities otherwise, where Joseph, as a teenager, was cognitively sort of about a 2-year-old cognitively. And then public education, that concept. Now, public schools are responsible for ensuring that every child receives this. Again, appropriate is the key term. So as we deal with parents, what is appropriate for Joe or Jane? And it's not always going to be what the parent wants. The parent is going to usually want more. For us with Joseph, it was, all right, he needed physical therapy, occupational therapy, and speech therapy. So we were negotiating with a school. They'd say, hey, he's going to get 10 minutes a week of physical therapy. Like, no, he needs more than that because he's learning how to walk, and 10 minutes a week isn't sufficient. And part of his public education is life skills and being ambulatory so that he can go to the next step. So it's not perfect, it's not excellent, it's appropriate is the term. So what does appropriate mean? Very few cases dealing with special education get to the U.S. Supreme Court, and very few are actually litigated in courts. Most of this happens in administrative agencies and mediation. But this is an example of where the word appropriate and appropriateness of an individualized education program was in play. So this is where the administrative law judge, the trial court, and the Court of Appeals all sided with the school system. And the standard that was being employed back at that time was that the program had to provide some educational benefit that was merely more than de minimis. Now, is that how we all raise our children? I just want to do just a little bit more than the bare minimum. Yeah. How's that feel for any child? Like, all right, we're going to send our child to Centerville, Richmond, Northeastern, wherever, and Charles School, whatever it is, and think that that school is going to just do more than minimum. So fortunately, the Supreme Court said, nope, that's not the law, that the plan, the individualized education program, has to be reasonably calculated to enable the child to make progress, appropriate in light of her circumstances. Again, individualized, every child's different. What's the progress we're trying to achieve? If it's a child with dyslexia, how do we help them manage and improve with that? If it's a child with a learning disability, if it's a child that has behavioral challenges, this needs to be reasonably calculated to make progress. No one can guarantee progress, right? But do we have a program in place that's going to help Joseph and Jane get from A to B and B to C? All right, so appropriate educational evaluation. So to get in the system, there needs to be an evaluation. And so the federal law requires schools to evaluate students suspected of having a disability. Now, so for some families like us with Joseph, a child who's clearly disabled, can't walk, can't speak, has various visual and other cognitive issues, very easy to know he's going to qualify. But yet he was still evaluated because we need to do an evaluation to determine, well, then what does he need that's different and special and tailored to him? How does this evaluation get triggered? So it can be the teacher or the parent, or it could be the cafeteria worker that says, something doesn't seem right with this third grader, and raise that and get that process started. And it can even start in early intervention, first steps in Indiana. And so that's very commonly parents initiating it, but the school staff, teachers are really that front line. And if you think of a kindergartner or first grader, second grader, that this teacher's been through. What grades do you teach, ma'am?
K through 2 special.
Well, there you go, right there. Okay. K through 2, there's a lot that we normally see in the normally progressing student. So that's sort of the front line of detecting, okay, this student might need some services because they're not on track and we're not sure why. So who's covered? So the evaluation is to determine whether the child meets this standard. And this is the standard that Congress passed, that Indiana adopted. And again, Indiana could go further and say, well, it could be because they're short or tall. I would have gotten additional services being the shortest kid in junior high throughout Richmond back at the time. But this makes sense. How would you define a child with a disability? So there's a bunch of words here. So intellectual, hearing, speech, language, visual, serious emotional disturbance, orthopedic, autism, traumatic brain, other health impairments. That's the big wide bucket. Or specific learning disabilities. So that's first. Does the child in an evaluation have those? And sometimes, by the way, it's the pediatrician or other medical provider that might first highlight that there's something going on here. Maybe it's the hearing test, that shows, hey, there's a hearing impairment. And then there's part 2, that because of that condition needs special education and related services. So there could be someone who has a visual impairment, let's say, that wears glasses or contacts and does not need any special education or related services. This is a very simple example. Then if the student is evaluated and determined to be eligible, then an individualized education program is determined for that student. That in a perfect world, and this works oftentimes very, very well, The evaluation says, here are the 3 issues, and then the program aims at each of those issues. And so for Joseph, we had orthopedic, we had cognitive, we had visual, and speech. You know, those were sort of the big buckets. And those change sometimes over time. All right, let's go to the individualized education program. So what this is aimed at is this, it's great for the Congress to write a law and then the legislature to say, all right, Department of Education, you pass some rules, then we pass some rules, and then nothing happens. All right? This is the implementation process whereby a child gets essentially this program, which is really a contract. It's kind of odd. You think, boy, you're negotiating a contract for a K through 2 student with the school. But that's really what's happening here. And it's the way parents and guardians should think about it. So it is to ensure that every child has access to what they're entitled to, free and appropriate public education. So it's a written document, as I say, basically a contract. It's developed by what's called the Case Conference Committee, sometimes shortened to CCC, but the Case Conference Committee is a legal term within the statute. That's basically the group that includes the parent or guardian that meets and works together to come up with this. And then that evaluation that determines eligibility is used to help devise what should the program be. You know, for Joseph, for instance, all right, there's enough going on in there that he's got some ability to communicate. So what are we going to do with speech? So his speech therapist was both working on trying to get some verbal speech, which he never was really able to develop, but she was able, with a communicative device, to get him to pick essentially A or B on a pad for some things. And so the goals were then, well, let's get him to 3 out of 5 times that he's able to correctly say A or B, yes or no. All right, the Case Conference Committee is defined by law to include the following people. So the reason I cover this is that if a parent goes to a Case Conference Committee or an educator is at a Case Conference Committee and says, wait a minute, I'm the special ed teacher and the parents here, where's everybody else? So, and certainly those 2 are key, but who else is part of that? So first is the school representative, knowledgeable and able to commit resources. That's money. Costs money to get a physical therapist, a speech therapist, a behavioral therapist, go down the line to provide services. And schools, some schools are big enough that they have that team. Very commonly, schools partner and contract with suppliers, vendors, service providers to say, all right, we're going to need more hours from physical therapy, and then that comes from some cooperative group. And so that depends on the school and the school system. It might be the principal, the vice principal, might be the director of special education. But it's somebody who, if our son, for instance, is going to need a communicative device that costs $600, the free and appropriate education that requires that device free is part of that, all right? And a lot of families aren't going to be able to afford that communicative device. So somebody's got to be there that can commit to that. Then there's the representative to speak about the specially designed instruction, the special education teacher, like my sister was. Then there's the general ed teacher, to the extent that there's general ed curriculum. So you think about maybe with dyslexia, you have a bright, sharp, cognitively functioning student, but has dyslexia. So what general classes can they stay in, including perhaps, honors algebra, but they need some additional assistance, whether it's in that classroom or with a specialist to help address that. Who else? So the teacher, whoever the student's actual teacher is, speech, then the speech pathologist or therapist. If general ed, then one of the student's general ed teachers. Parent guardian, if a student that's less than age 18. If the student is of legal age, 18 or older, that student of legal age is part of that committee, unless the student or parent opt out. Like for Joseph, for instance, he didn't have the cognitive ability. We didn't bring him into the case conference meeting because it's 45 to 75 minutes long, he's going to sit there and be bored. Others, there's one of my colleagues at my law firm has physical disabilities, extraordinarily bright. She started attending her case conferences when she was 14. And now she's an advocate doing this kind of work for families and students. The student that's age 18 and competent, and maybe they've got the concussion from soccer, they can go on their own. And that can be an interesting dispute between the parent and the child, kind of like college, where there's this wall all of a sudden and there's no knowledge that you get from the college about how your son or daughter is doing. But usually we don't see an issue with that in my experience. And then if it's for the initial determination of eligibility, a member of the evaluation team. So the evaluation team can include a lot of different people, usually a school psychologist, whether their specialists might be needed. So they're involved because they're the ones that just undertook this investment of time and brain power to get this done. All right, what does the case conference have to consider for the individualized education program? So the strengths of the student, concerns of the parent, behavior, language, assistive technology. Does the program provide the special education services that will meet the unique needs of the student, regardless of their disability? Transition plan if the child is getting towards aging out of coverage. So those are basic things that by law need to be considered. And there's a lot of sort of gap filler in between that, as you can imagine. But one of these concerns of parent is foremost. And you'll hear me emphasize this, bless you, how much parent involvement and parent knowledge really impacts how this plays out. So how does a parent or guardian prepare for the case conference meeting for the individualized education program? Obviously, need to know when it is, calendar the deadline for that. It's good to review what's the most recent evaluation, progress reports, and the current program plan, if the one's in place. Some parents are really good about guardians having all this notebooked and they bring it tabbed, they bring it with them. Others have it on their tablets or laptops. Back when we were dealing with Joseph, technology didn't make that particularly easy, so we tended to have those in folders and would always try to review in advance to get prepared. It's always a good idea for the parent to try to get the proposed individualized education program before going to the case conference meeting. This isn't a document that the parent drafts on their own and says, there you go, here's my proposal, like buying a car. Hey, I'm going to buy this used car for $10,000. Instead, it's the school takes the lead because they have the knowledge. There's a typical format, computerized, that makes it very efficient to prepare. But it's really helpful for the parent or guardian and anyone assisting to know in advance. For instance, for us, it was, all right, we were always negotiating minutes of PT, minutes of speech, minutes of occupational therapy. And then we would talk with our pediatrician amongst ourselves and sort of where is Joseph right now in his development and where do we want to tweak that, where are we going to advocate for more, and then where are we going to compromise? Because it really can oftentimes be a bit of a compromise trying to get the appropriate education, not necessarily the best or the most excellent. Identifying the strengths and concerns is really important for the parent. I give you an example for Joseph. He had orthopedic surgery, had a hip surgery when he was, I think, 8. Was in a full body spica cast that basically took him out of school for 6 weeks. As he got then back to school, our number one goal was getting him walking again. So load up on physical therapy, and occupational and speech can take a bit in the background. So a lot of these students have these evolution of their conditions, and those strengths and concerns are going to vary sometimes over time. What goals, what changes desired, and then talking in advance with everybody that's involved. If If the more the parent knows, the more involved the parent is, the better the relationship the parent has with everybody who's serving the child, the better. All right, attending the meeting, obviously want to bring the core materials in case they need to be referred to. As I mentioned, this program will usually be drafted and then talked through. Ma'am, did you say you're a special education teacher? Is this what your experience, that the IEP is basically template drafted before the conference? Yeah. It's good to, before walking into that meeting, to at least know what's going on and be talking with the people who are serving the child. And our view and what we lived ourselves and what we propose and suggest as counsel when we're assisting is this should be considered a working proposal. By law, it is. It's not like walking in when you close on a home for the mortgage or a car loan, and here's this long document you're signing that you have no ability to change. You're just going to say yes or no, or you're going to go shop for a lower interest rate. This should be thought of as a give and take, negotiated document. And sometimes revisions are made right on the screen, by whoever's controlling it and typing, yes, okay, let's focus a little more on this. Sometimes it's printed and worked through. It depends on, each school and each teacher, et cetera, how they do this. Really needs to be an open conversation. And this is one of the challenges that, and what would you say the average number for you, ma'am, as a special education teacher, in the number of people in the room in your case conferences? More or less than 5 people? Okay, right there. Sometimes as many as 10? All right, that was our experience. Ma'am, go ahead, your question.
How long does it take to get an IEP?
How long does it take to get an IEP? That's going to vary widely, but it's not days. It's usually potentially weeks or months. Kind of depends on where we start and where we go. I don't know, what's the quickest turnaround you have, ma'am, as a teacher? New student coming in kindergarten.
60 days.
60 days, there you go. Okay. And so the earlier you're on it as a parent and guardian and being proactive, you can help move things along. And figuring also, like through your own pediatrician, your own service providers, if you have them, get as much information. Again, open conversation between all individuals present. So I was just mentioning 5 to 10 other people are typically in the room besides the parent, and oftentimes the parent's the single mom or the aunt or the grandmother or guardian. And this is what they do professionally. And just like when we go to the doctor sometimes, or the dentist, and there's terms being tossed around that we don't understand, slow down and say, I'm sorry, I don't understand that term. Could you please explain that to me? It's helpful to have another human being with you. Someone who loves you, someone who supports you, knows you, whether it's a sister, relative, neighbor, who's another set of eyes and ears, because there's going to be a lot of things discussed. It's hard to listen and take notes at the same time. And it can be, in particularly the first 1 or 2 of these. Here I am, a trial lawyer. I'm used to fighting all the time for clients in court. And I remember our first IEP, I had no idea what was going on. I've never been in one of these before. So it's good to have somebody else with you for support. All right, least restricted environment, that concept under the law that exists. Some parents really, really focus on this. And they want Joe or Jane, mainstreamed in every course, sometimes to the detriment of the child, because the child may really need some separate, individualized, special education. Fortunately, I think the labels and the negative bias that came with being a special ed student, hopefully that's evolving and disappearing. But for the parent and for the child that really needs the least restrictive environment, this is part of the law. And so if I use dyslexia as an example, a child who's otherwise performing well academically but needs some additional service in mainstream general education, that could well happen, where every class is the same with the others, but there's some additional or special services being provided. That placement's discussed by the case conference committee. You've got to explore the alternatives, modify classroom modifications, supplemental aids. Think about the, and I keep going to this because I coach at a high school in Indianapolis, and I see, fortunately not our athletes who are runners, track and field and cross country, but I see soccer players, football players with concussions. And think about the concussed student who's got essentially a brain injury, at least for a little while until they recover. They get to whether it's days or weeks, they're back in school, but they've got a sensitivity to light. How can they still get through calculus? Well, we may need to have them in the back of the room with those parts of the lights turned off, right? That may be the simple accommodation that's needed that allows them to stay moving forward. What about parental participation in placement decisions? So the parent is an equal participant and decision maker, even though you feel outnumbered. And all these other people do this professionally, and they know the terms, and they're very experienced. The parent really needs to think of themselves as, hey, I'm an equal here, and I'm going to do the best by my child to make sure my child gets the free and appropriate public education. We'll talk about how, well, I'll just mention this right now. It's true in life generally that getting along gets more done than not getting along. And so having positive, healthy relationships with the teachers, with the staff, with the therapist, with the vice principal is helpful. It just is. There are times, and we had this once, where Joseph, who had integrated physical education, which was available to do with 20 other kids in the class, he could be in the wheelchair and still have some activities that he could benefit from. And we liked that also, because one, he's getting a little bit of socialization. It wasn't the school's job to do this, but we liked it that the other students are seeing Joseph, and that impacts them. He got kicked out of PE, and the gym teacher said, well, he's crying and in my class. And we found out, well, he was crying because he could stand and walk some, but she would have him standing against the wall for 10 minutes. Joseph could handle about 3 minutes of that, the way he was structured orthopedically. So we had to advocate and correct that situation. We did it diplomatically, but the first thing was having the discussion with the teacher that is not your class. It's Joseph's class, and it's everyone else's class. And you have an obligation to make this right. And we had to go above her to make sure that happened. And then we did everything we could to create a very, very positive relationship with her. So that, one, Joseph wouldn't be, I say punished, not in the mean-spirited way, but that doesn't feel good for a professional to be told you can't do this or you're doing it wrong. So that friendly, cooperative approach is always the best way to go, than just knowing that there may be times where you've got to do more. You're entitled to notification of a planned evaluation, involvement in all the meetings. You have the right to refuse further evaluations. Now, we're pro-evaluation, the way we counsel families, parents. If a school says, hey, we're going to do another evaluation, either because they think the student's improved and doesn't need services, or because they think there's something else that needs to be looked at more commonly, you want that. Got to be invited to all the case conference meetings. Procedural safeguards, so there's a responsibility, as you'd expect, to inform the parent guardian of their rights. And those include notice. Hey, we're going to hold a case conference. We propose, I'll just say we're getting towards the fall and your child starts, when do you start school again? Too early?
6th, I think.
6th of August, yeah. So let's say the case conference is scheduled for September 10. I'm just making that up. Well, you're entitled to notice whatever the prescribed period of time is in advance. What if that doesn't work? Well, you've got a right to participate, and if the parent cannot get off work for that but could do it on another day, it's not the only date that's available. But the earlier that's brought up, the easier it is for the school to realign everyone that has to participate. Confidentiality. All of this is confidential. Now, obviously, if Joseph is in a certain class getting certain assistance, that's publicly available and seen by his classmates, but all the details otherwise are confidential. Access to records. We'll get calls from parents and they're concerned, they've got questions, and the first thing we ask is, all right, does your daughter have an individualized education program? Like, what's that? Has your child been evaluated? I don't know. So first thing is, well, we got to ask the school for the records. I'm not the best record keeper in my own life. I am as a lawyer for my clients, but sometimes I don't have the records that I need just in navigating life. So that's a common thing. Fortunately, the schools are good about that, about keeping that, and technology has made that much easier. Dispute resolution. If there is a dispute, there's a process through which that can get resolved that includes mediation, which is a negotiation process, an administrative hearing. So it's not like if you can't get the plan you wanted, you've got to go to court. There are steps in between that kind of address that. Okay, I just want to note something I always share with parents and lawyers and educators already know this. So it's not specifically a special education law, but every state has laws like this that are aimed to protect children. And I raise it just so that we don't just think about it in special education, but we think about it when we're in the grocery and we see somebody haul off and hit a 6-year-old. And like, what do we do? Do you get in the middle of it and get shot? Or do you just walk away and say it's none of my business? The law says that an individual who has reason to believe a child is a victim of child abuse and neglect shall make a report. And that it needs to be made immediately, either orally or in writing. Fortunately, there's a very easy way to do this orally. It has to be to the department or local law enforcement. The department is the Department of Child Services, and sometimes it's easy to criticize federal or state or local government because they're not doing enough. This is a great program, staffed 24/7. I've had to call it a number of times. Some people I work with have had to call it. It gets answered. They're polite. They take the information. What's reason to believe? The law says reason to believe is that evidence that if people of similar background or training would cause them to believe the child was abused or neglected. Okay. So abuse could be, a number of bruises that just keep showing up. Now, it may well be there's a reason for that. And the child has a blood disorder and bleeds easily and bruises easily. But something like that can be the reason to believe. Fair to report, by the way, if we don't report, it's a crime. It's a Class B misdemeanor. Immediate case law, actually, it's a really sad case. It was a high school in Indianapolis where there was an alleged rape. So that's child abuse and neglect. Okay, child, by the way, is under the age of 18 in the statute. So I'm talking about seniors in high school. So that's what this was. Reported alleged rape, and the school principal essentially started an internal investigation. Wasn't until 4 hours later that a report was made to DCS. He was prosecuted, he was convicted, and the United Supreme Court affirmed it. And this is just the key language here. That's not anybody's job, including the principal, to investigate. The responsibility is placed with DCS and law enforcement. We're really all the tripwires that we make the report, and then professionals undertake the investigation. You might say, well, gosh, what if I see something tonight and I call? Or it's the neighbor and I don't want them to know. Well, one, it can be anonymous. You don't have to say who you are. You're also, by law, the statute provides immunity for making a report in good faith, and you're presumed to be acting in good faith. And here's a case where a hospital was sued because they made a report, and I think, no, they made it in good faith. So always have to say as a close on that topic that it's a unfortunate topic that we need to even raise. During the pandemic, the number of reports of child abuse and neglect decreased significantly. The reason for that is the children weren't in school. The schools are the first tripwire. And then healthcare providers, but pediatrician might see the child once a year, or the dentist, or go down the line. But 180 days a year, hopefully, or pretty good attendance close to that, our children are being seen by lots of skilled, educated, trained people that care about children. So I just raise it. So my goal was always give you basic information about special education so you kind of know where to start. And also, the more people that know about this duty to report, the safer our children are. And I say I've had this several times where I've had to make the call, or others have asked me, they start to tell me, hey, I learned of this. I'm like, stop. You go make the call, then you email me and let me know what you said. So I've got a record of that. But with that, any questions? And while we've got the benefit of a special education teacher, anything that you'd like to share both for the group here and remotely? What's your number one tip to a parent?
Advocate.
Advocate. Okay.
Advocate.
There you go. Right from the teacher. It's the teachers, and my sister went through this for almost 40 years. She doesn't control the budget, and she could only go so far in trying to enact change, particularly at a macro level across a whole classroom. It really takes each parent, each guardian, to advocate for the best, the change for their child, that then hopefully others will benefit from that as well. Any other thoughts, questions? Don't hesitate.
Okay, this year I have my great-granddaughter, and she
You're too young for to have a great-granddaughter, but
she has a behavior problem.
okay.
And the first part, she was in kindergarten last year, and her first part of the year, she was doing pretty good, except in the afternoon she started getting in a little trouble, and then they had a counselor there to help her. Well, something triggered her after Christmas. I don't know what, since the break or whatever, but then they started letting her only go till 11:30. Wouldn't let her stay the whole day.
Okay.
And then it got so bad that I'd get her to school and I'd have to come back and get her for 30 minutes.
So behavior issues and
Yeah.
yeah.
And so they said, well, we're going to send her to Baxter. They sent her to Baxter. And I asked for an IEP. And I kept asking to meet with the principal. They wouldn't meet with me. Oh, we'll get back with you. I was at the school. I mean, I attended the parent-teachers conference
Okay.
and all that stuff.
So do you know whether she's been evaluated?
I took her to Dr. Woodland, and I'm working on an IEP
Okay.
now through him. He says he will go and speak to the school.
Okay. So we'll finish up here and go off camera. This is sort of a classic example of has the school done an evaluation, which they're required to, but you're doing the right thing to start getting one on your own. And while you're in the summer, sort of working towards getting things ready and getting started. So we can chat for a few minutes afterwards about helping you get started. But that's a common issue. And the challenge for schools, back when I was a kid, somebody misbehaved, well, they were just punished. And we didn't know that they might have had ADHD or been on the spectrum, and there wasn't maybe therapy and treatment. There wasn't therapy available. So the schools have this challenge of the child that may be more difficult to manage than the average child and maintain order and discipline, but also comply with this child's rights to an appropriate education. But fortunately, there's a way to navigate that. So we'll talk offline on that. I wanted to share on the last page these resources. Indiana's Department of Education website and its special education site, which is literally just the doe.in.gov/special ed, a really good website. It has the law, it has that resource book, it has lots of information. So those of us that are involved in special education as parents, families, it's a good one to go ahead and have bookmarked. This resource center on IEPs, the U.S. Department of Education website, the navigating the course reference, the full Article 7 if you really want to drill in. Parents can do this because you could start with that navigating the course guide, trying to figure out certain things, and then it'll refer you to the overall site where you could go read the actual law for yourself. Some examples of procedural safeguards. So I wanted to provide that to you as well. Thanks for being here. Those of you watching remotely, if you have questions about any of this, reach out to whitewatervalleyprobono.org. You'll find Felicia's information there, both email and phone on the website. And there's never a question that shouldn't be asked in this regard. And we may not be able to answer it immediately, but we can usually get you pointed in the right direction. And then what we also do is match families, parents with a volunteer attorney to help guide. And then one of the things we'll start to do more of is we're doing a number of these programs sponsored by the Wayne County Foundation, these educational series on different common legal issues. We've got a wills clinic that's coming up this fall. And on the special education side, if there's enough interest and demand, we could potentially do with our Ask a Lawyer programs that we do once a month, the first Thursday of every month here at Morrison Reeves generally. That's another good way to show up with these kinds of questions, particularly if you let Felicia know in advance, hey, I'm going to show up, I'm going to have some questions about special education. We'll make sure we've got some volunteers available that can speak to those. And that's all free. And we don't ask for proof of income or not for those Ask a Lawyers. We're not measuring poverty level and all that. Very few people can afford to walk into a lawyer's office and write a big check to get a couple hours of advice. We recognize that. We're trying to help fill that. Well, with that, thanks for being here and those of you watching online, and thanks for your interest in Whitewater Valley Pro Bono.